So today, what we're going to cover, first off, we're going to talk about what a will does, what happens without a will. We're going to go over 5 real-life situations, well, really real-life nightmares if you have no will. 3 easy ways that you can get things started, and then we're also going to talk about the process, through our firm to get the ball rolling to do your own will. So wills, misunderstood and unappreciated. Did you know that 2 out of 3 Americans do not have a will at all? There's a lot of reasons why people don't do wills. One problem is procrastination, which I think a lot of us can relate to. We know we need to do something like get a will done, but we just don't know how to start, and we keep putting it off. The second is that people believe a will is too expensive to do, which can be true. In estate planning through a private attorney outside of LegalShield can be a very expensive proposition, could easily, run into the thousands of dollars. Some people don't understand why they need a will at all, and today we're going to go over a few of those reasons. The LegalShield plan really is a solution to a lot of these problems, which you're going to see today. So what does a will do? A will, first off, very simply, it allows you to direct the distribution of your estate, who will inherit what you own when you pass away, whether it's your house or your collections or your bank accounts, whatever it is that you own, you can say who gets it. And also you can put in charge who will handle the estate and handle the assets that you own after you pass away. It's going to let you appoint somebody that you trust to manage your estate. That's called your executor. And they will see to it that the will is carried out according to your wishes. A will also allows you to appoint somebody to care for your minor children. That is called a legal guardian, and the will is the place to put that information. Also, if you have minor children, you can use the will to put restrictions on when that minor child can access their money. Also, it doesn't just have to be a minor child. Sometimes you have a young adult child that you'd like to have some restrictions placed on. That can be done as well. And in fact, it doesn't have to be your child at all. It could be a minor godchild or a niece or nephew or a younger sibling, a friend's child, something like that. You can also use a will to make gifts to non-family members, such as partners, stepchildren, friends. Another thing that people might be surprised to find out is that if you don't do a will yourself, the government has a will for you. You may not like that will, but it is there. It's called the Laws of Intestate Succession. And right now, the trust in the government is pretty much at an all-time low. So, would you really trust the government to distribute your estate the way that you want? Probably not. The American family has changed, but the intestacy laws have really remained stagnant and don't reflect things that are happening now. Things like grandparents who may be primary caregivers for their grandchildren, in vitro fertilization, unmarried couples, same-sex marriages and things like that are not taken into consideration under the state law will whatsoever. So what assets does a will not control? This comes as a surprise to some people as well. There are certain things that the will has no control over. One of them is jointly titled assets. such as bank accounts, deeds to your house, or other real estate. Many times, if you have a joint owner on an asset, when you pass away, that joint owner receives the entire property, bank account, or whatever it is. Even if you set that up prior to doing the will will not change that. Another thing that is not controlled by wills is anything that you have designated a beneficiary on. An example of that would be a life insurance policy, an IRA, a 401k plan, a pension plan, something like that. If you have designated beneficiaries already, the will does not control it. And again, even if you sign a will later, it doesn't override the beneficiary designations. Those will hold even if they're outdated and they were done many years ago. So that has to be carefully looked at, when we're working on your estate plan. Another thing that your will does not control most of the time are assets that are in a trust. So you may have put your own assets in a trust, and that trust will distribute things at your death, or you may actually be the beneficiary of a trust fund somebody else set up for you. And most of the time, that trust fund is going to say who gets whatever's left of your share of that trust when you pass away. But there are times that the person making the trust gave permission in the trust to let you say who gets what's left of your share. And if that's the case, we might be able to control that in the will. So that's another thing we have to take a very careful look at. So no will nightmares. We call no will nightmares situations where somebody passes away without a will, and it really would have made much more sense for them to have a will. Once you get an understanding of what would happen if you don't have a will, sometimes that will make it seem very urgent to you that you need to get a will very quickly, which happens a lot when I'm talking to my clients. They'll come to realize they really need this will, and how fast can you get this to me? So we're going to go over 5 real life situations and consequences of having no will at all. The first one is blended families. If you are married and you have children from a prior marriage or a prior relationship, without a will, half of your estate will pass to your spouse and the other half will go to your children. So that may not work for you if you want your spouse to inherit your whole estate, or you want your spouse to inherit your house so they can continue living there. Or you may want it in reverse, and you may want actually a larger share of the estate to go to your children. Also, without a will, there's no guardian identified for who will manage any of that money for minor children. So that can cause some pretty serious problems. What happens if you have no will and you're unmarried, but you're in a couple? The survivor of that couple gets nothing. It doesn't matter how long you've been together. You could have been together for 30 years. If the person in the couple who passed away owned the house, the survivor has no right, to live in the house, and may find themselves scrambling to find somewhere else to live. So very, very important to get a will in those situations. The law does not take into account unmarried couples. What happens if you have stepchildren with no will? Well, guess what? Your stepchildren get absolutely nothing. It doesn't matter if you raised them since they were a young child, you treat them as your own children. None of that matters. According to state law, stepchildren are not included in your estate whatsoever. So if you do have stepchildren and you want them included, then absolutely you have to do a will to specify that. The same goes for step grandchildren, by the way. Single parents, that's another scenario. Who is going to manage any assets left to those children? Who do you trust to put in charge of your children's assets? If you're divorced, do you trust your ex to manage their money? In most cases, probably not. So you need a will to designate your own trustee of your choice. Even if you want your ex to still manage their money, it's a good idea to get a will and put that in writing, by the way. And who would care for your children if they were under 18? There is no parent that's capable of raising the children. This is really the place where you need to specify who's in charge. You're going to know best of who can take care of your children, who you want to be for them to live with and care for them. So what if you're single and you have no will? Sometimes a single person may think, I really don't need a will. I don't have anybody that counts on me for their support. And what's the point of me doing a will? But those estates can run into problems. Under state law, if your parents are living, they are next in line to inherit. If they are elderly and perhaps incapacitated, that can create problems because they're not going to be capable of becoming an administrator, and they're not even going to be capable of signing the papers to waive away their rights on that. They may be in a nursing home receiving a medical assistance, and if they receive an inheritance from you, it's going to disrupt their eligibility for medical assistance, or maybe if they're receiving the waiver program for in-home care, getting an inheritance may disrupt their grant money. So it's very important to sort of take a look at that for a single person, with no children. Also, who's in charge of handling the estate? To pick the best person, the close friend or the sibling who's best capable of managing things, so that there's not a dispute later after you pass away and that goes to court and costs more money and delay to get your estate settled. So what are some ways to get your will started? There are three options. You can do it through the LegalShield Will app. You can use a paper questionnaire, or you can go to our firm website and get started that way. The LegalShield Will app is downloadable from iTunes or Google Play. You can get started anywhere, anytime. You can work on your questionnaire at 2 o'clock in the morning if you feel like. You can also request a questionnaire from your LegalShield associate, or you can download one and print it off from our firm website, which is www.fiffiklaw.com. You can also go to our website and submit a form online, and that will get the ball rolling for you. You can also call into the firm and just ask for me if you want to, and I'm happy to sort of get things started for you, or to answer some preliminary questions too. Before you begin, there is some information that you have to start gathering. We're going to need some basic information, obviously your name, your contact information, your date of birth, your marital status, who your spouse is, your children's names, what their ages are, whether or not you have a prenuptial agreement or any sort of postnuptial or property settlement agreement in a divorce, whether or not you have a mentally or physically disabled beneficiary that might require some special planning, whether or not you or your spouse are a U.S. citizen or a green card holder. And you're going to want to give some thought about who you will pick to be your executor, the person that settles the estate for you and carries out your wishes in the will. If you have minor children, who you're going to list for their guardian, who you would like to list for their financial trustee to manage their money. until they reach the age that you select. And the guardian and trustee can be the same person, but it does not have to be the same person. There are going to be questions on our form about your assets and debts, what the value is of those assets, and how they're titled. Very, very important on how they're titled, because as we had mentioned earlier, not everything that you own passes through the will. So we want to clarify that for you and go over options to make sure that your estate is flowing in the way that you intend. Also to list any out-of-state property, so we can talk about perhaps some planning tools to use if you own property out of state. And if you want to give away any specific bequests, an example of that is could be personal possessions, anything from jewelry to collectibles, but it also could be a piece of real estate, your house, or a specific bank account or an investment or a bond, something along those lines. If that's supposed to go to one person as opposed to equally amongst a group of heirs, you know, we'd want to know about that too. So you can start thinking about that. Once you submit your form, or even beforehand, by the way, remember to give us a call with any questions. Everybody's situation is different. We're probably going to have to gather some additional information from you once we get the questionnaire in from you. So I'll go over that process a little bit so you'll know what to expect. When we receive it, we do open an intake. That's a file for you that will be opened on it. You will receive a confirmation email or a text message letting you know that we have received your request to prepare the will. And then you will get a contact. You will get a contact from our law firm. We will have a staff person give you a call just to gather any additional information needed or any clarification. An attorney will review your questionnaire and your situation, and we'll call you to talk to you about any legal questions that you might have. And then we'll review your documents. We'll mail everything out. You're going to get instructions on how to properly sign your documents at the notary and what's involved there. And we strive to put everything in the mail within 5 business days from the date that we have all of your final decisions from that date. We can also email too if you want your documents sent that way. So a complete estate planning package, which we do provide, would be your last will and testament. That's what gives away your assets after you pass away. And then the next 2 listed here, the power of attorneys, are lifetime documents. Durable power of attorney is a way for you to appoint somebody who can sign checks and pay bills and manage your financial affairs while you're living. And a medical power of attorney is a way to designate somebody who can arrange for your medical care, your personal care, and consult with your doctors if you lose the mental ability to manage your own medical decisions yourself. So those are 2 important documents that are oftentimes done the same time a will is prepared. We cover all of those in our package for you if you want them, any or all, but all 3 would be considered a complete package. There are some special situations. If you have a beneficiary who is receiving SSI benefits, they may benefit from doing something called a special needs trust to protect your gift to them so that it can be used for medical expenses or other necessities not covered by the government benefits. So that is a special planning situation. If you have children with special needs or other beneficiaries in that category, there is a question on the questionnaire that asks you about that, but we'll be happy to go over that with you and talk about the options there and make a decision on the best way to handle that. Also, high value estates. If you have a high value estate, there may be some special tax planning that will want to talk to you about. So that is another situation, and we'll be happy to take a closer look at if you fit into that category. Living trusts, that's another special situation. Living trusts are a different type of tool that it can be used in place of a will. Sometimes it is useful for members who have property out of state. So if you own a vacation home in Florida or New Jersey, or rental property in a neighboring state or something like that, and you may wish to actually avoid your executor from having to go through probate in each state separately. So a trust can be established for that property, and that's something we'd be happy to talk to you about. The living trust also gives some level of additional privacy because they are not probated at the courthouse and not made public record. So it's a little harder to view them. And also, if you're somebody who wants to put more control on how and when your beneficiaries get their assets, if you want to stretch out when they get it, when they get their assets over a period of years, living trust might be something to think about or talk about. We do cover those under the preferred member discount, and we would be happy to discuss living trust with you further if that's something you're interested in. There are some other resources that you might want to take a look at our website, fiffiklaw.com/trust and estate planning. Fiffik Law on YouTube. We've got some great videos on there. And also Pennsylvania Intestate Evaluator is another tool that you might want to take a peek at. So, of course, this presentation really contained general information, was not intended to be specific legal advice to anybody, but we are more than happy to give you very specific legal advice to your situation. So don't hesitate to call, Fiffik Law Group, and we'll talk you through it. And that brings us to the end of the presentation.
Hey, Jen, we have a couple questions here.
Absolutely.
If you want to, you can stop sharing your screen if you want.
Okay. Yes.
All right. So the first question is from Harvey Fox. For high value estates, can you give an example of what you might advise someone who has a farm that is valued at 1.5 million?
Well, when we were talking about the high value estates, there's a federal estate tax, okay? And the exemption amount is over 10 million right now. In fact, I think it's over 11 million right now. And if you're a married couple, it can actually wind up being double that. So there's no federal estate tax on a $1.5 million farm. But there may be some issues about how that farm is used, after after your death, or who's in charge of it, or how you want it to be passed down on through the family as a legacy. So that could definitely be a special situation. Maybe talking about a trust to hold that property.
The next question is, if you have a high value estate, I heard it doesn't make sense to have a will. Would a living trust be a better approach?
Well, maybe. You can do trusts inside of a will, okay? That can help, that can protect and help you limit those federal estate taxes just the same as you would do inside of a living trust. So you would believe it or not, you put a trust inside of a living trust that would function at your death, but similar trusts can be placed inside of a will. So there's no right or wrong answer there. You can actually successfully plan a high value estate with a will as well.
Okay, Harvey has another question. If someone owns a high value business, how do you recommend that it be structured to minimize taxes passing to the owner?
Tell you, Harvey, that's a really sort of a complicated question that is really specific to that person's situation. I think it's probably a little bit beyond what I could get into right here. But we'd certainly be able to talk to you about that more specifically.
Okay.
Separately.
If you receive assets under a will as a beneficiary, does the recipient generally pay income taxes on those assets received?
No, it is not income. There's no income tax whatsoever. It's strictly a gift to them.
So if someone's listed as a beneficiary to an IRA or something along those lines, Jen, they don't pay taxes?
Well, if the IRA owes income taxes, yes, there's going to have to be income tax paid on that. But by virtue of, but generally speaking, if they're a beneficiary, say in a life insurance policy or a Roth IRA or something like that, no, there's not going to be an income tax. But they won't escape the income tax if it's owed, just like you don't when you're collecting it as you retire. That's true.
This was a quiet bunch today. Do we have any more questions? If anybody wants to unmute themselves and ask a question, please feel free to.
Hello, it's Marlene.
Hi, Marlene.
Hi, a great presentation. I just want to know what other items we can include in the will process, like, for example, instructions when you pass, like cremation, or what to do with, say, business activities that you have in process. Are those things included? All the things when somebody dies that you have to handle. Are those things included, or is there a process there? Thanks.
Yeah, sure. Well, I do. When people are filling out their questionnaires, it's a good idea for them to write out to us if they have special requests about cremation or burial. And we will talk to them about whether or not the will is the best place to put that. Sometimes we can make a short statement in the will, but sometimes we do it by way of a separate letter, just depending, because if the will doesn't get found or looked at until after the funeral or nobody knows where the will is, it may not be the best place to put that information. But by all means, it's a good idea to give it to us so that we can talk to you about it and figure out, what the best way is to handle that for you. And I think your other question had to do with a business owner, perhaps.
Yeah.
Yes. Yeah. Absolutely. If you're a business owner, we want to make sure we want to know about that so that we can talk to you about it and go over, options and what to consider. You may wind up needing something a little more complex than just, the basic will. But we would want to hear about that so that we can talk to you about how best to deal with those issues.
Kind of related to that, based on your experience, what would you say are the things that catch people off guard when somebody gets sick and incapacitated or die, and now you're stuck? What are the things you're seeing that people don't prepare for, aside from what you just mentioned, especially when it comes to money?
Yeah. I'd say one of the biggest things is not having a durable power of attorney in place for finances. That it can be a very, very difficult problem for family. If somebody unexpectedly loses their capacity, and there's no power of attorney in place, not even a spouse can sign on everything. So some major problems can result there without having a good, solid, durable power of attorney in place.
So in practice, you're saying we get that from you and we literally copy that and give it to if there's multiple people, and make sure they have it immediately. Is that it?
Well, so we prepare it for the client and they decide when they're ready to give it out. You know, it is a very powerful document. So a lot of clients will sign that power of attorney, keep it in a safe place, and they will hand it out to the person they named when they are ready for them to start using it, or make sure, you know, that the person would have access to it if they did lose capacity. Whether or not it's given out at the time they sign it is sort of a personal decision, but definitely get it signed, get it in place, and get it stored somewhere, and make sure somebody else has access to it to bring it out when the time is right. Does that make sense?
Yes, thank you.
Mhm,
The
mhm.
reason, just so you know, the reason why I ask is like I'm traveling overseas and
Yes.
I've heard stories of things that happen to other people when traveling. And it, like if you're a single female, especially, what do you have in place so people can help and there's no delay for help?
Yes. Right. So you're going to want to have a durable power of attorney in place, and probably a medical power of attorney too, in case there was an illness involved.
Okay, great. Thank you so much.
You're welcome.
Do we have any other questions?
One last one, if nobody
Mhm.
does.
Go ahead.
I'm single and I'm thinking about these things. So the other issue, you just mentioned a mother or having a parent and you're a single person and
Yes.
what arrangements you make there. So the other thing I'm thinking about is what do we need to do with regards to insurance that we need to let you guys know? Like if I went to get a term life policy, what are the things that you can do to help to make that happen smoothly if I go?
So we're going to want to talk to you about whether or not you have beneficiaries set up on that policy, whether or not you have a primary beneficiary and even a secondary beneficiary, because the primary person, what if they're traveling with you, or they pass away and you are incompetent yourself and incapable of updating the forms. And we're going to want to, you know, make sure that if you have a minor beneficiary listed, that there's a trust fund somewhere in place that can accept that money and the right person is in charge as trustee. Or if you have an adult person who maybe is incapacitated and couldn't manage that money, that there was perhaps a trust in place to accept that insurance money for those reasons.
Great, thank you.
You're welcome. Any other questions?
All right, if we don't have any other questions, I wanted to let everybody know that Fiffik Law Group, we updated our website. So go take a look at it. They did an amazing job with it. And always follow us on social media, on Facebook, Twitter, and Instagram. And if you have any questions, please feel free to give us a call. And we're also on YouTube. If you search Fiffik Law Group, we have past presentations that we have done posted on there, and this one will be posted within a couple of days.
Can I add one other thing?
Sure.
Yeah, I just want to tell you guys thanks. You guys are really the best at educating folks on just life stuff that happens and doing it consistently. So I just want to salute you guys for that. And because you do such a great job, one of the things, and you've done so much already and you see what's happening in the world, what would be really cool is if you share more stories, more of the nightmare and the horror stories of what happens when trauma or drama strikes or when somebody passes, beyond having the paperwork and all of that in order. What are the types of things you're seeing people having to struggle and deal with quietly that we don't typically hear about immediately after the event, and then like after with cleaning up what's left behind? It'd be really cool to hear some of the stories you're seeing just to scare more people.
No, that's a very good suggestion. Our marketing manager coordinator is on their presentation, so he heard you, and we'll take that back to Mike and our team and let them know that you'd like to see that. Maybe we could post a story on it on our social media account.
That's a good idea. And I'll just follow up with Marlene. One of the big things is, and the presentation touched on it a little bit, it's so important to have a will to have an executor named, because that is one thing that there are oftentimes so many disputes about, especially if it's a large family with either a lot of children or a lot of siblings, and there's no will, and the family cannot come to agreement on who will serve as the administrator. So it costs, sometimes the estates take forever to get settled, and there's a lot of litigation and expense. So that's a major problem. It's a very good reason to have a will.
Yeah, so if you could talk more about the litigation and the expense and doing probate in multiple states and stuff like that. We don't hear about those except for the people who are actually going through it. And by
Right.
then it's too late. So
Yeah.
that'd be good
Okay.
stuff. Thank
Okay,
you.
good. You're welcome. Did I see another question flash up, Noemi? No.
Sorry, I keep doing that too, Jen. I keep muting myself and then I forget and I start talking. In very general terms, what might be the cost of a will supporting docs when compared to a trust and the supporting docs?
The trust is probably going to be double or triple the amount of a will. And there is some expense because if you own real estate, the deeds, your deeds have to be redone and re-recorded into the name of the trust. So there's in addition to the preparation of the trust, there has to be a deed created. There's a fee for that, and then the recording fee that's charged by the recorder of deeds office. If you have multiple properties, you can times all those fees by you know, the number of properties you have. So that can really increase the expense of a trust.
One last question from Marlene. I'm single, so if something happens, and would my family be able to use your services because it's my membership? Is that how it works? After someone passes away, is their family coming to LegalShield to take the ball on? Is that it?
Yes, they can actually call in, you know, under your membership. Let us know. We will. I mean, they're not a covered person under your membership, but we'll certainly have a courtesy consultation with them to get, you know, things started, and then you know.
We can also provide a referral, Jen.
Exactly.
Mhm.
Exactly.
So the best thing is for them to actually be a member, because then they're gonna be able to handle everything as a member. And then it would be covered, right?
That would help, right, Noemi? But either way, we can do a referral.
We could do a referral as long as the decedent was a member or former member of LegalShield. We will do a referral, and we'll, you know, if there's any discounts associated with probating the estate, we at the firm at Fiffik Law Group will pass that on to that person as well.
Okay, great.
But yes, sell more memberships. So yes, let's get some more members.
And then Primerica has, you know, some different rules, different coverages for probate.
Okay, well, if nobody has any more questions, we're going to go ahead and we'll end this session. And again, thank you all for giving up your time to attend our webinars. We really, really appreciate you. And everyone have a wonderful afternoon.
Thank you, everybody.
Bye.
Bye-bye.